Are we ready then, ladies and gentlemen? Mr. Munro is anxious to make his submissions. Mr. Henry is trying to knock the pillar down. At least we'd have a better line of sight if that happened, Mr. Henry. Right. Mr. Munro, please.
Thank you, sir. Sir, my client, Susan Sinclair, and my firm came into the inquiry midway through Phase 4. As a result, others are far better placed to address many of the core issues surrounding this terrible scandal, and have done so in comprehensive and skillfully made submissions. We have instead sought to focus on a discrete issue, namely the experiences of those wrongly accused and prosecuted in Scotland. And we are very grateful to you and to the inquiry team as a whole for allowing us to attend and offer these submissions. So the experiences of those affected in Scotland, as against those in the rest of the UK, had many similarities. The same terrible accounts of careers, families, lives destroyed, of institutional cruelty, of systematic injustice. But there were also several important differences, and I urge the inquiry to keep those differences in mind, not only so that we in Scotland can benefit from any specific recommendations that this inquiry can make, but also so that the Scottish experience can inform the analysis of what might need to change across this United Kingdom. Events north of the border, for instance, might cast some doubt on the impact that stripping POL of the right to privately prosecute in England and Wales will have, or would have had that happened earlier. I propose to begin by outlining some key differences in the system as between Scotland and the rest of the UK, and I'll try to identify 4 broad categories, if I may. The first main point of contrast is that, broadly speaking, all prosecutions in Scotland are brought in the name of the Crown, specifically by the Crown Office and Procurator Fiscal Service, with the Lord Advocate at its head. There is no tradition of private prosecutions in Scotland. Whilst technically that is a remedy that is available, it is all but extinct. POL, as a result, could not prosecute directly in Scotland. It was instead a Specialist Reporting Agency, or SRA. There are in the region of 40 or 50 such bodies, largely public authorities, and arguably the only one that appeared on that list that was a commercial enterprise was POL, and arguably the only one which had a financial interest in the outcome of prosecutions and on any proceeds of crime procedure that may follow was POL. The role of an SRA in the Scottish system is akin to that of the police in a normal conventional prosecution: to investigate, to detect evidence of criminality, to report. Interestingly, while the Crown has a statutory right to direct and instruct the police with regard to the investigation and reporting of criminal offences, there is no corresponding provision in relation to SRAs. I will return to the issue of revelation and disclosure, but to note briefly here, SRAs are, as with the police, under a duty of revelation in terms of the Criminal Justice and Licensing Scotland Act 2010, and are obliged to comply with the Crown's Code of Practice on disclosure of evidence in criminal proceedings. And that, read short, requires SRAs to comply with a number of core responsibilities, including conducting reasonable lines of inquiry, identifying and investigating exculpatory information, and revealing information to the Crown, and, as a whole, in submitting accurate standard prosecution reports, the template by which all criminal matters are reported to the Crown in Scotland. COPFS also issues guidance to SRAs, including guidance on disclosure, which has, we were told by the Deputy Crown Agent, a senior official at COPFS, Kenny Donnelly, has apparently existed in one shape or form since the mid-1990s. Training is also offered by COPFS, and Mr Donnelly told the inquiry that between 2000 and 2013, COPFS would routinely meet with SRAs to provide guidance and advice. There was an annual training conference held for SRAs from 2003 onwards regarding the reporting of cases to COPFS. And training regarding the duties of disclosure specifically was delivered to SRAs, including POL, we are told, in 2009. Despite those efforts by the Crown, however, it was apparent from the evidence that there was a profound lack of knowledge in POL about its duties under the Scottish system. Robert Daly, for instance, a Scottish POL investigator, gave evidence in Phase 4 of the inquiry, and he said that while those at POL did indeed receive copies of the guidance issued by SRAs, or to SRAs by COPFS, his earliest memory of any formal training was in 2009. And he recognised there was generally a lack of knowledge within POL when it came to Scots criminal law. He himself did not feel adequately supported by POL's criminal law team for the work that he was doing in Scotland. Raymond Grant described the training he received as a bone of contention. Jarnail Singh, the inquiry will recollect, the head of criminal law at POL, clearly had little understanding of the Prosecutor's Code and the duties of disclosure in England and Wales. So there was little chance of him understanding the distinct and discrete duties that POL had under the Scottish system. And even when the current Chief Executive of Post Office, Nick Reid, came to give evidence to this inquiry on the 11th of October 2024, a matter of weeks ago, the position of POL as an SRA in Scotland was not something he was aware of. I will return to the issue of revelation and disclosure a little later on, but if I can say this, it is worth stressing that the relevant rules are not difficult. Everything relevant must be revealed. It might be seen that there were gaps in the institutional knowledge in POL in respect of its legal position in Scotland. But even allowing for that, there was no obvious need for POL, or indeed any SRA, to obtain external legal support, and certainly not at the level of individual cases. Unlike elsewhere in the UK, POL was not a prosecuting authority. The reason for its decision to specifically engage external Scottish lawyers, BTO, in 2013 was never established. That created an odd dynamic, I suggest, having on the one hand a privileged relationship with lawyers, dealing with individual cases, while on the other having absolute duties of revelation. The second main point of contrast between the Scottish and other domestic systems relates to the substantive law, and I can touch on this very briefly. The Fraud Act does not apply in Scotland. Most financial crimes in Scotland are governed by the common law, and the typical charge in POL cases was one of embezzlement, which, read short, involves the dishonest appropriation of funds belonging to another whilst entrusted to the accused. The third and perhaps more substantial point of contrast relates to evidential and procedural distinctions. Perhaps the most obvious distinction, and it's one that has been referred to in written submissions lodged by other parties, is the requirement in Scots law for corroboration, a rule that goes back centuries. Nobody, in principle, can be convicted on the basis of a single source of evidence. But it is important to understand the extent of this. There is no requirement for every fact in a criminal case to be corroborated. Corroboration simply extends to the fact that an offence was committed and the accused was the person who committed it. Conviction does not require there to be two strong independent sources. Where there is one strong source, all that is generally needed is something that is capable of pointing in the same direction. It's about providing an independent check on the primary source of evidence. And that was the case here. Horizon was presented as a very strong source of evidence to show that funds had been appropriated. The fact of Horizon's reliability did not in and of itself require to be corroborated. What did, namely that an offence had been committed, was, from the Crown's perspective, typically supported by the words of accused persons when confronted by investigators, very often confronted in their own homes or in private places of work. The corroboration requirement in Scotland is often seen as providing a balance to other peculiar features of the Scottish system that may be less well known to practitioners south of the border. including, firstly, in jury cases, the ability of the jury to convict by a simple majority. I should stress that although some cases in Scotland were prosecuted on indictment, there's no evidence of any actually going as far as a jury trial. Secondly, the absence of equivalent powers to those contained in Section 78 of the Criminal Evidence Act of 1984 and Sections 125 and 126 of the Criminal Justice Act 2003, essentially allowing the court to exclude unfair evidence and to exclude hearsay evidence. And thirdly, and importantly, I respectfully submit, until 2010, suspects in Scotland were not regarded as having any right to legal advice and representation during suspect interviews. Scotland did not experience the scandals of the 1980s that led to the passing of the Police and Criminal Evidence Act 1984, an act which does not apply north of the border. Indeed, as recently as 2009, a full bench of the Scottish Criminal Appeal Court held that there was no unfairness arising from the Crown's reliance on admissions given during a police interview where the accused had been unrepresented. For the avoidance of doubt, that wasn't a Horizon case. But the court's view, even as late as 2009, was that the absence of the right to representation in a suspect interview was balanced by other features of the system, such as corroboration. The following year, however, in 2010, the United Kingdom Supreme Court, in the case of Cadder, unanimously disagreed with that approach and held that the absence of the right to representation created a breach of Article 6 of the Convention. I will return to the question of suspect interviews and their salience when dealing with the matter of corroboration later. The next point to make is the prosecutorial test applied by the Crown in Scotland differs from that applied, for instance, by the CPS today. It does not include a reasonable prospect of conviction leg. Instead, the focus is on technical sufficiency and the public interest. And then finally, another salient point is Section 196 of the Criminal Procedure Scotland Act 1995, which obliges courts to take account of the point at which an intention to plead guilty was intimated when determining sentence. In practice, that means a discount for early pleas. The fourth and final main category of contrast, sir, relates to the statutory scheme for revelation and disclosure of evidence, which is now found in Part 6 of the Criminal Justice and Licensing Scotland Act 2010. And the process by which that came into being was not, I might submit, Scotland's finest hour. Previously, there was no statutory regime for disclosure. The Criminal Proceedings and Investigation Act in England and Wales did not extend to Scotland. The system instead operated on trust, the premise that the Crown would disclose what was appropriate. Statements given by witnesses to the police, for instance, were not routinely disclosed to the defence. The defence would be given a list of witnesses and would have to carry out its own investigations. And following a series of decisions before the Privy Council, including the cases of Sinclair in 2005 and MacDonald in 2008, the position developed, initially with the Crown issuing a practice statement on disclosure in more serious cases, and then eventually the legislative framework that came in 2010. The 2010 Act requires an investigating agency, usually the police, but an SRA as well, to reveal all relevant information to the Crown, and that's sections 117 and 119 for summary and solemn cases respectively. The Crown then requires to disclose all information meeting the statutory test, in essence, evidence which is part of the Crown case, evidence which materially weakens the Crown case, or evidence which materially strengthens the defence case, to the defence as soon as reasonably practicable. And the statutory duty of revelation persists during the lifetime of the case, but the Crown's guidance makes it clear that that continues beyond as well, at least at common law, and at least in terms of convention compliance. The Crown's duty, the duty to disclose to the defence, continues in perpetuity. Section 137 of the 2010 Act makes that clear, and it continues after the final disposal of a case. There is also a concomitant statutory duty in the Crown to review information held even after the conclusion of a case. Now, having set out that framework, I now turn to the question of how that worked in practice in Scottish cases.
before you do, can I just ask you a question? Because you told me that, I think, that given the special status conferred upon the Post Office, during the course of a trial, the duty of revelation or disclosure would be imposed upon them. But did that persist once there'd been a conviction, so far as the Post Office is concerned?
Post Office as an SRA did not have a statutory duty to reveal, but the Crown made it clear in its training and protocols that it took the view that they had a common law and convention duty to reveal in perpetuity.
Right.
So while there wasn't a statutory provision that could be pointed to, that was the understanding of the prosecution authorities.
Thank you.
Thank you. As I say, there were undoubted failures in revelation. To take as an example, COPFS representatives met with POL in September 2013. It was a meeting arranged to discuss the findings of the Second Sight and Helen Rose reports and whether the defects identified in the system were present in any live or pending prosecutions. And we now know that during that meeting, POL failed to mention or otherwise disclose the Simon Clarke advice notes from July and August of that year relating to Gareth Jenkins. Redacted versions of these advice notes were only made available by POL to COPFS in 2023, 10 years later, in the context of the criminal appeal proceedings that took place before the Scottish Criminal Appeal Court. POL also failed to reveal the true extent of problems with Horizon, and indeed that issues were in fact identified with Legacy Horizon, which had been operational from 2000 to 2010. And then, and even until recently, the Crown seemingly did not know about the existence and role of Fujitsu in supplying the Horizon data, resulting in no attempt to secure information directly from that company. Although it appears that Gareth Jenkins was never involved in a Scottish prosecution, the disclosure of Simon Clarke's advice to COPFS at this meeting would have provided an important indicator as to A, the existence of Fujitsu in providing POL with the underlying Horizon data, B, potential issues surrounding the reliability of such data and the ability for this to be spoken to and supported at trial, and C, the possibility of POL shredding, or at least not handing over, information relating to issues with Horizon, contrary to its duty of revelation. So what did the Crown know and when? Kenneth Donnelly, the Deputy Crown Agent, says that between 2000 and 2013, COPFS was not institutionally aware of the bugs, errors and defects in the Horizon system. No record is held, he said, which suggests that POL provided details of any issues with Horizon prior to May 2013. That being said, we know of one case where information about the reliability of Horizon featured in 2012, the case of Allied Cloisterhouse. In mid-2012, her solicitor wrote to the Crown and referred to his client being, quotes, aware from the national newspapers that the accounting system used by Post Office counters is currently being questioned on its accuracy. And it remains unclear why the national press concerns had not been picked up on by the Crown's policy unit at that time. We know of other instances, such as a report by a Procurator Fiscal Depute in May 2014, that's Andrew Lazarin in the criminal case against Rosemary Stewart, where he comments on well-publicised concerns about the reliability of the Horizon system. A similar comment was made in a later report in the case of Murtaza Razul by the same prosecutor, who said the problems concerning the Horizon system were widely reported at the time, so will probably be something that the defence focus on. Clearly, these were matters that were known about by the Crown at that stage. But upon receipt of the Helen Rose and Second Sight reports in 2014, COPFS decided that these reports did not meet the statutory test for disclosure. Given POL's assurances that the bugs, errors and defects identified did not impact live or concluded cases, and further action was to be taken by POL for the purposes of future prosecutions which were reliant on Horizon evidence. That decision, in retrospect, is very difficult to understand. Horizon evidence formed the basis upon which the prosecution proved appropriation. These reports materially undermined the reliability of that evidence, evidence which was crucial in securing convictions. And, of course, by 2019, we have the Bates judgment, and nobody could be any clearer on what had gone wrong. Yet there was no attempt to alert convicted persons to that information, even then, notwithstanding the clear relevance to the convictions and the statutory duty in Section 137 of disclosure in perpetuity. The Crown did not undertake its own retrospective review of closed cases upon disclosure of the Second Sight and Helen Rose reports in 2013. It trusted what POL said. Only in recent months has its own internal review determined that of the 148 cases between 2000 and 2020 originally identified as being potentially impacted by issues with Horizon, 52 are considered now as giving rise to miscarriage of justice due to reliance on faulty Horizon evidence. So what do we now know of Horizon prosecutions in Scotland? Mr Donnelly confirmed that, quotes, of the cases identified by CUPFS in its recent review of cases in which a conviction may have been impacted by Horizon unreliability, that was something like 60 cases, only one case went to trial, Susan Sinclair's. In every other case, every sub-postmaster prosecution relying on Horizon evidence concluded in a guilty plea. As Mr Donnelly said, in a significant proportion of these cases, the accused sub-postmaster had admitted the offence during an interview with POL investigators at the initial investigation stage. These admissions will have formed a major plank of prosecution cases and will have provided the necessary corroboration. These admissions were generally not given in police stations. They were not video recorded, at least until 2010, and in many cases beyond that. The suspects did not have access to legal advice or representation prior to or during their interviews. In the case of Colin Smith, for instance, and the instances that I'm going to refer to are all drawn from the appeal court decision that forms part of the inquiry's papers. Colin Smith, apparent admissions given at the time of the audit, not repeated in subsequent interview, were what were relied upon for corroboration. The court concluded in the appeal that these could not be regarded as having been given freely and consistently, but rather arose from the seemingly indisputable evidence with which he was faced. Horizon infallible. In the case of Ali Cloisterhouse, whom I've mentioned, the Post Office investigator submitted a, quotes, incorrect and misleading, close quotes, standard prosecution report to the Crown, which essentially misreported the position regarding admissions that had been made. Admissions made in an interview in 2011, so after the Supreme Court decision in Cadder, without legal representatives present, in her small post office on an island on the west coast of Scotland. She, quotes, declined, close quotes, the opportunity of having a lawyer attend. Even where Horizon evidence was originally challenged by the defence, such as in the case of William Quarm, who originally pled not guilty in 2010, and a forensic accountant was instructed, the Horizon system was deemed to be watertight. Mr Quarm was left with no real choice, as he saw it, but to tender a plea of guilty to, quotes, simply get the matter resolved. Tragically, he died before he was able to clear his name. Robert Thompson is another gentleman. He was put in a position where his original account of innocence was deemed impossible by POL investigators based on the supposed reliability of Horizon. Thus, his eventual admission was not freely obtained. The inquiry didn't hear from any defence solicitors or counsel instructed for those accused in Scotland. But the assumed reliability of a computer system developed by Fujitsu and rolled out by a major public institution, combined with the damning effect of a perceived admission, were likely to have led both accused and their legal representatives to the conclusion that the allegations were nigh on impossible to defend. The alternative, plead guilty to a restricted charge, secure a lesser sentence, was likely to have been seen as irresistible. And in the one Scottish case where we know an accused person went to trial, Susan Sinclair, we see how that went. To quote the Lord Justice Clark, Scotland's second most senior judge, in the appeal court decision, in convicting her, Susan Sinclair, the sheriff relied on the fact that she had continued to deny any wrongdoing without providing a coherent explanation. So her persistent denials were somehow regarded as corroborative of her guilt. According to Lord Justice Clark, quotes, "There could hardly have been a clearer case of a miscarriage of justice having regard to the disclosure issues." Susan Sinclair was convicted in 2004. It took 19 years for her conviction to be overturned. And yet the Crown was aware of difficulties with Horizon from at least 2013. In the written submissions, which were tendered last week to the inquiry, I returned to 4 questions that had been posed in the Phase 4 submissions. And rather than going into detail of them, I simply refer to what was said and pose and answer them. Did the involvement of COPFS afford greater protections to those accused in Scotland? In my submission, no, is the answer. Did POL understand and discharge its duties as an SRA? Plainly, no. A real question, I should add, arises as to whether it should ever have had the status of SRA, given its commercial nature and financial interest in the outcome. But the next question, did COPFS comply with its duty of continuing disclosure? No, and had it done so, people like Susan Sinclair would have been able to take steps to try and clear their name at a much earlier time than turned out to be the case. And finally this, did corroboration act as a safeguard? No. Simply put, it appears that nobody was able or prepared to look past Horizon evidence, which was held to be the strongest piece of evidence justifying prosecution, leading to a confirmation bias. Everything, even protestations of innocence, were then regarded as corroborative. In any event, the ability of investigators to wrest admissions from vulnerable suspects neutered the safeguard of corroboration. A much more productive approach would have been to look for corroboration elsewhere, such as in the type of financial audits so common in criminal confiscation applications, and to investigate the totality of the crime alleged. Evidence of an increased availability of funds not matched by declared income would have acted as an independent check on the Horizon evidence, but such further checks were generally not carried out. They weren't necessary because the Crown or POL had what they needed. And there's no better evidence of that than again in the case of Susan Sinclair, where the Crown did in fact lead evidence from a Post Office auditor at the trial, who said that he had not attempted to trace the alleged missing money, as this was, quotes, not part of his remit. In other Scottish cases, the accused were prosecuted without any independent evidence of theft and loss beyond Horizon. Sir, I would end, if I may, with a rhetorical question. What confidence can we have that this scandal could not happen now, whether in a Post Office setting or otherwise? Are we, as a society or as a justice system, any less trusting of large-scale proprietary computer systems? Are we any less inclined to rush to judgment, to see everything through the prism of our initial conclusions? Are we sure that our public prosecutors will be better able and better equipped to spot patterns, investigate concerns, and disclose all relevant information without delay? Are we sure that comments made by terrified suspects, faced by investigators who repeatedly insist on the impossibility of their denials, will not be regarded as evidentially significant? And finally, nobody who is innocent should ever plead guilty. But are we sure that a vulnerable accused person, finding themselves in the position that countless sub-postmasters did, would not conclude that a guilty plea was their only conceivable option? There are, we suggest, several measures that would lead to these questions being answered in a more positive way, some of which include an expectation of a cultural shift so that lines of defence are not dismissed out of hand but professionally and properly investigated. Independent investigation of potentially criminal allegations by properly trained police officers, not agency employees who have a financial interest in the outcome. Recognition of trends and patterns, as Mr. Steen alluded to, but in this case by police and prosecution, having a proper oversight so that common threads can be investigated. And a clear recognition that computer systems we do not properly understand should not be assumed to be infallible. A matter of ever greater importance, I submit, as we move into a world of machine learning, artificial intelligence, where going and checking the codebook isn't nearly as simple as it once was. As Mr. Maloney reminded us in his submission, in the words of Tim Brentnell, it wasn't Horizon that prosecuted the SPMs. And finally this, a focus on searching for corroboration in its truest form, not tick box checking, but evidence that provides a proper independent check on the allegation made. This inquiry, sir, has performed a vital function. It has shone an arc light into these appalling events, and the victims of this appalling scandal trust that it will produce robust recommendations that will prevent, or at least limit, the chances of something similar happening again. I'm obliged.
Thank you very much, Mr. Munro. So I think Ms. Watt next, yeah? She's moved. That's why I was slightly taken out of my stride. Yeah, there you are, Ms. Watt.
Just keeping you on your toes, sir.
Yeah, well, it's very important you all do that.
Sir, the National Federation of Sub-Postmasters, the NFSP, takes this opportunity to reiterate its thanks to you, this inquiry, its legal and counsel team, and all of those who have supported and worked to make it run as smoothly as it has. The NFSP looks forward to the publication of your report, and we make the following oral closing statement to add to the original opening statement and the closing submissions for phases 2, 3, 4, 5, 6 and 7. The NFSP also endorses and adopts what the submissions of Howe & Co, Hudgels and HJA on behalf of their clients in respect of their position and comments on Post Office, UKGI, Government and Paula Venos. The NFSP, without repeating them all here, adopts and endorses the recommendations and requests made in the written closing submission produced by Howe & Co. I would also say, in setting off in these closing submissions, that the submissions for the NFSP, having fully engaged with the inquiry and fully reflected on its place in the history of Horizon, are made both with reference to the present and the future, as well as to the past, all of which fall within the inquiry's terms of reference. Sir, whatever the motto for the Post Office is today, the phrase from Dante's Inferno, "Abandon hope, all ye who enter here," is the one that was metaphorically across the top of the door for all those postmasters, assistants and Crown Office employees who had the misfortune to be the victims of the bugs, errors and defects of the Horizon system, and even greater misfortune to have been victims of the Post Office's toxic culture, which saw a ruthless and relentless prosecution and recovery strategy over many years, culminating in its full-scale defence of the GLO court actions. There seemed to be no hope for the users of Horizon who were investigated and prosecuted, or those who became broken financially paying for shortfalls which the system generated. No hope for each individual presented with Horizon data, advised to plead guilty in the face of the evidence to avoid a more severe sentence, told they were the only one and geographically distant from anyone else in a similar situation. No hope for the loss of their reputations, families, finances, and in some tragic cases, their lives, all at the hands of the Post Office. Another translation of Dante's phrase is, "Abandon all hope, ye who enter." But, sir, the placement of the "all" in this translation suggests there is and can be no hope at all. It is submitted that that is not necessarily the case. In the Greek myth of Pandora's box, after all the evils had escaped, when it was opened, hope remained inside. And, sir, the hope that sits at the bottom of the Post Office box of evils resides with you and your inquiry. The hope that through the inquiry's dogged determination eventually to recover all the documents, its focus on the compensation schemes, and its careful interrogation of the documentary evidence and witnesses, there will be an outcome and recommendations from your report which ensures a dreadful, terrible thing such as the Horizon scandal can never happen again. Hope, sir, is to expect the good, while fear is to expect the evil. Hope, expecting the good, is and must be a good thing. However, it is submitted for the NFSP that based on Phase 7's evidence, we are unfortunately still somewhere between hope and fear in terms of the future of the Post Office, its culture and governance, the role of UKGI and government, and most importantly, the role, status and remuneration of the key investors and stakeholders in the business, the postmasters. For far too long and far too often, taking account of the actual views and input of postmasters and their representatives has been ignored or sidelined. True engagement has been illusory, and everything that was said over the years to the NFSP and to others by the Post Office has turned out not to be true. Just taking a few examples. Horizon was robust, not true. Prosecutions were safe, not true. Recoveries were required under the postmaster contract in all circumstances, not true. Network transformation would provide services and products which would transform the earnings and businesses of postmasters, not true. But that was then, and this is now. Sadly, however, despite all the time that has passed, all that became known from the court cases, and everything that has subsequently come out in the inquiry, still many, many issues remain. As the Phase 7 evidence has shown, a very great deal is unresolved, including, but not limited to, ongoing lack of proper redress for the thousands of victims of prosecutions and shortfall recoveries, lack of transformation in the Post Office's culture and governance, past roles and the failure to recognise and deal with those involved, postmaster relationships with and trust in the Post Office, postmaster remuneration, the continuing use of and reliance on Horizon as the operating system meantime, NBIT, delays, spiralling costs and likely lack of suitability of the Horizon replacement, public trust in the Post Office. Those whose lives and finances were ruined still do not have the redress they deserve, whether through the overturned convictions compensation scheme, the group litigation order compensation scheme, the Horizon shortfall scheme. Alongside that, the victims have also had to hear that some of those who had involvement in the Horizon scandal years, even where no direct wrongdoing, somehow ended up working on and assessing applications in the very compensation schemes for what went wrong during their employment. Worse, the victims have had to hear that it was only in the last 18 months or so that the Post Office thought to examine this and move some people. And only even more recently, following direct interventions by the Post Office, that the Post Office took steps to relieve past roles individuals who are now current senior people at the Post Office from their postmaster-facing roles. At the present time, there's no confidence that Horizon in its current form can be relied upon, and now has come the news that the government may no longer be going to fund the already scandal-hit proposed Horizon successor, NBIT. Due to have replaced Horizon in March 2024 at a cost of approximately $200 million, it has spiralled out of control, had costs escalating into the billions, has IT equipment purchased sitting in warehouses, all in a further demonstration of the lack of board and UKGI oversight, their lack of risk identification, and without there even having been clarity to them that the final product would in fact be fit for purpose. That all sounds very familiar when we think back to what we heard in Phase 2 about the procurement of Horizon. Now the existing Horizon will remain in place, complete with its bugs, errors and defects. And while it was wrong for Post Office to prosecute and recover money on the basis of a faulty system, equally the Post Office is certainly losing money which it legitimately is owed, but is paralysed from doing anything about. It's submitted that it's hard to imagine how things could get any worse for postmasters who have to live with the system, for taxpayers and government who have to fund the replacement for Horizon, however long that may now take, and for the public and their lack of trust in the Post Office brand. The inquiry has heard that inertia and paralysis are widespread both at senior management and board level in respect of decision-making at Post Office, and that culture change and significant governance improvements needed have not yet happened. Some minor changes have been magnified, made to look as if they are bigger than they actually are. For instance, that postmaster engagement and postmaster views are being taken seriously by the creation of 2 postmaster non-executive directors on the board. However, sadly, in a demonstration that little has moved on from the Horizon years, both the postmaster NEDs have been or are being investigated by the Post Office, and one gave evidence to the inquiry about the heavy-handed way in which this has been done. This evidence sat alongside the evidence of both postmaster NEDs that they felt they were not being listened to at the board. As well as this, the issue of conflict of interest has meant postmaster NEDs cannot vote or even sometimes participate in matters which affect them directly as postmasters, such as the vexed issue of remuneration. Postmasters have reported through the inquiry's YouGov survey that they feel they are not kept informed by the postmaster NEDs. Meanwhile, the inquiry heard that it's a necessary part of being a board member that some matters remain confidential. While there is a suggestion in at least one core participant submission that increasing the number of postmaster NEDs is a solution, it is submitted for the NFSP it is not the solution, and it doesn't and can't change the issues that arise from the inevitable conflict of interest. Yes, they can give the board some additional insight from those individual postmasters, NEDs, and their experience, but it doesn't change the fact they may not be able to participate in some discussions or some votes. It doesn't change that they still won't be able to share information from the board due to confidentiality. And importantly, they have no real or formal mechanism for engaging with and obtaining the views of a wide and diverse range of many thousands of postmasters, which an organisation like the NFSP does. The postmasters' NEDs may be complementary to, but they must not be the last word in postmaster representation. That it is submitted is a job they and the role they are in is simply not one they can or should do. Anyone on the NFSP's analysis going into the postmaster NED role in the next changeover, thinking they'll be able to campaign, influence or change the Post Office's mind on strategy with the focus of postmaster benefit, will have to be mindful of their director duties under sections 170 to 176 of the Companies Act, which means they will always have to compromise on their own personal and business interests as a postmaster to ensure they fulfil their duty to act in the best interests of the company, which in this instance is the Post Office. In addition to this, it is submitted that everything said, heard and seen, Post Office simply cannot be trusted not to control every narrative, every aspect of what is to happen to postmasters and their businesses and their remuneration, and not necessarily for the betterment of postmasters. It's not just that rabbits are coming out of the hat with astonishing speed, but also the timing of what is being said about the future is incomprehensible when the work and scrutiny of the inquiry and the stage it has reached is taken into account, including the announcement of the New Deal, a so-called transformation plan, made public on the last day of the inquiry's evidence sessions on the 13th of November. Ironically, when the expert witness was giving evidence on appropriate governance arrangements at the Post Office, and which includes the proposed closure of over 100 Crown Post Offices. Apart from the loss of the Crown Post Offices and the hundreds of job losses involved, there was next to no consultation with representative bodies such as the CWU and the NFSP on the detail of what was announced. It's certainly not clear what the headline-grabbing sum in the face of publicised postmaster remuneration being at the top of the list of priorities for postmasters is going to equate to. Potentially a transformation that may not be an actual transformation, and certainly not one that has had any real meaningful engagement with postmasters and their representatives. A strategic review presentation pack provided to the inquiry after the conclusion of evidence, which meant it could not be scrutinised in any way by the inquiry, and those representing the key core participants could not interrogate it. A strategic review presentation pack that is exactly that, a presentation. No detail as to how any of those objectives are going to be achieved, no consultation with the NFSP on what was in the presentation pack, despite it having more than 6,800 postmaster members. A transformation plan that introduces a so-called consultative council, a postmaster panel, to work with the Post Office to deliver the transformation plan. It is submitted that this simply reinforces rather than changes the way in which Post Office consults, delivers and transforms. In other words, yet another illusory mechanism purporting to show engagement with postmasters while retaining the control over the plan, its delivery and who can comment on it. It's submitted that a postmaster panel run by and appointed by the Post Office could not actually realistically challenge senior management and the board about a plan which will by then have been approved by government and therefore not subject to any real change. But it will allow the Post Office to say it has consulted some postmasters. A strategic review and transformation plan that simply doesn't take account of the current and ongoing failures of governance, budgeting and relationships, which mean that despite the transformation, an unreliable Horizon system will remain in place, with NBIT, as I mentioned, over budget, badly managed and well overdue. The NBIT project is the perfect example of how little has changed despite everything that this inquiry has heard. A senior management which knows what happened in the Horizon procurement, rollout and introduction, a board which also knows the same, a board which has UKGI represented on it. It's not so much that the governance and oversight of Post Office is credible, rather that it is incredible. It is still capable of this astonishing failure, and with no real plan identified in the transformation plan as to what will happen. In relation to the proposition within the strategic review of the Post Office as a franchiser, the NFSP has concerns about such a model as compared to the goal of mutualisation, quite a different thing. As Callum Greenhow said in his first witness statement at paragraph 343, the NFSP is aware that franchising has been proposed as another way forward for the Post Office. We believe this would cause a movement of risk from Post Office to postmasters. Under a franchising model, it's likely that postmasters would have to pay the Post Office to provide Post Office services within their branch. They would also have to lease the IT equipment from Post Office. If there was an issue with the IT equipment causing a loss to the postmaster rather than the Post Office would automatically carry the loss, and until they could prove that the fault was with the Post Office's IT system, and they would then have to pursue the Post Office for the loss. It may be that franchising could be held out by the Post Office as increasing postmaster remuneration. However, how exactly this increase is generated is unclear, and the movement to this model would mask a significant transfer of risk and cost to the postmaster. The NFSP's position remains that mutualisation should be the goal. It's submitted that the postmasters need certainty that their investment partner, Post Office, has a vision to make sure their businesses are at the very least sustainable, and that there is a plan for the future. Postmasters today are facing an attrition of business and associated remuneration. Traditional streams of revenue are decreasing, and the government work promised to them under network transformation simply did not happen. Indeed, some government work is in fact being removed, an example being the DVLA contract, which NFSP has campaigned to get extended to March 2025 and has now been further extended until 2026. But it's still due to come to an end in the next few years. The postmasters of today are expected to carry out a public service and have continued to do so at great personal sacrifice. However, it's submitted that the government and Post Office have been unwilling or unable to repay postmaster investment and public service with appropriate stewardship of the network, including a long-term strategy that would enable their businesses to be viable. While there is some encouragement to be taken from movement towards having a long-term strategic direction for Post Office and the network, there's a lack of detail about what it actually means, other than it aims to change the polarisation of Post Office, and that there is an objective to increase postmaster remuneration. Early reports suggest it's intended there will be a decrease in central costs, and there may be a closure programme or transfer of ownership of Crown offices. The CWU has hit out against the proposal and the way in which it was announced with little or no warning. For the NFSP, there is a significant lack of detail about what the new deal actually involves. how the supposed increase in remuneration are meant to become a reality, and at a practical level, how a viable network is to be achieved. This makes the NFSP wary about the New Deal. Postmasters have been subject to numerous change programmes: the Network Urban Reinvention in 2003, Network Change in 2007, and Network Transformation in 2012. None of these change programmes transformed the business of postmasters other than a largely negative way. And of course we have what happened with Horizon, with Network Transformation in particular being missold to postmasters and the NFSP in a blaze of ultimately unfulfilled promises. It was a transformation that promised many new services to be provided by government in exchange for large-scale closures and changes to the business model and method of remuneration. Postmasters today, sir, remain worse off because of network transformation and those unfulfilled promises. And that all sits alongside the Horizon scandal. It's submitted that feedback from postmasters in the NFSP could only have made the New Deal stronger. Surely, when determining whether this is a plan that is sensible, it could only have been a useful thing for the government actively to seek the views of postmasters and the NFSP as to whether this would actually work in practice. On what basis should the government determine whether the plan was otherwise a sensible one? The NFSP questions how postmaster-centric the New Deal can be if postmasters and their representatives have not been consulted or feedback sought on it before publication. As already mentioned, the timing of the announcement of the New Deal and the proposed timeline of the government's Green Paper has meant this inquiry is now unable to scrutinise and comment upon these, and in particular to answer with certainty the questions posed at the inquiry's term of reference E. As mentioned already, the announcement of the New Deal itself fell on the last day of the inquiry's evidential hearings. Even the strategic review, despite being dated 21 October 2024, was made available only on Friday 6 December, one working day, or the last working day, before the deadline for written submissions by core participants to this inquiry, and the review cannot be examined through the evidential hearings. It is unclear if the timing is designed to avoid this scrutiny, but this scrutiny would have been an opportunity for the government and the Post Office to benefit from the experience and insights of an inquiry that has been examining these pertinent issues for a number of years. The scrutiny would also have given postmasters some confidence that the strategic review, the New Deal and the Green Paper on the future of the Post Office has been examined and commented on by the inquiry. The examination and comment of the inquiry would be independent from Post Office or government, who, it is submitted, carry much of the responsibility for this scandal in the first place. The NFSP does not want sections of the inquiry's report, when published, to be cherry-picked out of context simply to support a Green Paper or a New Deal, but without the inquiry ever having been able to scrutinise these. Therefore, as has been mentioned this morning, the NFSP submits there may be a need to resume the inquiry briefly at a later point prior to the issuing of your report, sir, to check what is actually going to happen with the New Deal so that the answers to the questions in terms of reference E can be answered fully. Given the Post Office's history of selectively focusing on aspects of reports, unfortunately, this cannot be considered to be beyond the cherry-picking, cannot be considered to be beyond the realm of possibility. Taking the behaviour, failure to change, and ironically the failure to transform itself, it's submitted that it's essential for something independent to be put in place, as the NFSP considers the evidence in Phase 7 shows that the answers to the questions in the inquiry's terms of reference at E, 1 and 2 Roman numerals and at F currently have to be: no, the processes provided by the Post Office are not sufficient to enable postmasters to run their businesses, and no, the inquiry cannot be satisfied that relevant controls are in place to avoid issues such as have taken place do not happen again. It's submitted that the evidence of the past phases and the evidence of the current position in Phase 7 of the inquiry has shown that simply the Post Office rearranging the deck chairs does not bring material and relevant change. It submitted that the failure of both Post Office and government to grasp the real issues of culture and governance mean that the NFSP's proposal for an oversight committee, or something akin to it, is what is needed to restore the trust of the public and postmasters and to ensure the appropriate level of curiosity, challenge and risk identification actually comes into being. It submitted that this inquiry has heard evidence of significant concerns about the governance of Post Office, as I have said. The NFSP has been trying to bring attention to these concerns. If we think about the key findings of the Grant Thornton report, it said there was an inability to unlock a unified purpose and shared ambition around a longer-term vision and strategy between Paul and its shareholder. There was an unconscious bias around the lack of accountability. There was a lack of clarity around the practical application of foundational governance documents. Decision-making forums appear to lack a clear understanding of objectives, roles and responsibilities. On culture, the misalignment on accountabilities between Paul, DBT and UKGI is culminating in a failing working relationship. These key findings go to the heart of the expected and best practice governance principles as outlined in Dame Sandra Dawson and Dr. Katie Stewart's first report. While it is the case that in response to the NFSP's questions on an oversight committee, that Dame Sandra said the ideal model was a board that was properly functioning, able to challenge and interrogate the Post Office senior management, it is the NFSP's position that sadly we are not anywhere near that being a reality. The NFSP agrees that this should be an organisation able to operate and manage itself in accordance with the principles of the Companies Act, the Nolan Principles, and with social purpose front and centre of all it does. Right now, the production of the transformation plan, strategic review, the timing of announcements, the lack of consultation, and the way in which things such as a consultative council are apparently to be set out without so much as a by your leave from postmasters and their representatives, shows that Dame Sandra's ideal is some way off. The evidence before the inquiry is submitted indicates that since the GLO, time and time again, Post Office governance has failed, despite attempts to change its internal culture and governance. For example, the improvements to culture and governance cited by the Post Office as being a protective factor against a similar scandal happening again have not prevented the Post Office's decision after the JLO to nevertheless pay leadership bonuses in full, which they had to be talked out of by Sir Alec Chisholm, the payment of Nick Reed's incentive payment prior to shareholder approval, the payment of bonuses, which NFSP calls Bonusgate, that was the one related to the fulfilling the inquiry's requirements, the requirement for the past roles review or Project Phoenix as motivated by the inquiry, not by the Post Office itself, 5 years' worth of delays in the compensation schemes, mounting significant concerns about NBIT, what will happen if NBIT is indeed abandoned and Horizon is not fit for purpose. That does not mean the NFSP considers that an accountable, fully functioning board cannot be achieved. Rather, something urgent and independent needs to be put in place, even if temporarily, or even if with a role which changes over time. And it asks this inquiry to consider seriously that proposal. It is interesting to note that Sir Alec Chisholm, former Permanent Secretary at what is now the DBT, was open to the possibility of an independent committee to scrutinise arm's-length bodies with mandatory reporting responsibilities to their board and the authority to write to the Secretary of State with concerns. While he thought that in a perfect world you wouldn't need it, he did note that in the particular circumstances of the Post Office, where the board had failed in its oversight responsibilities and the management executive and internal legal teams had failed over many years to provide effective service, causing a terrific breakdown in trust with both postmasters and the wider public, special measures such as an independent oversight committee might well be required. And while the submissions of the DBT commit the government to bringing forward legislation for a legal duty of candour to be introduced for all public servants and public bodies, this is welcomed by the NFSP as absolutely necessary. It's also submitted that at this time it's not enough. I will turn to matters such as representation, past roles and recommendations towards the end of these oral submissions. But it's the NFSP's submission that its proposal for an independent oversight committee is something the inquiry should consider seriously. It has been refined and revised, and it has gone to Boston Consulting, the group working with DBT on the future of the Post Office. It's submitted it's an imperative to have something which is outside of the control of the Post Office and even UKGI, which, it is submitted, has not shown sufficient insight into the failings of its NEDs and its advice to DBT over many years. The idea of an independent body with representative bodies and consumer champions, which therefore have both the interests of the Post Office, government, postmasters and the public at its heart, already experienced, knowledgeable in Post Office issues and able to see what needs challenged in the way the previous iterations did not, is essential. The Oversight Committee has its aims and purpose to expand on the existing shareholder relationship framework that currently exists between the Government and Post Office, while retaining its social purpose. The NFSP believes that the Oversight Committee would be a vital new tool in the toolkit of Post Office government. It is used and seen in a number of other public sector areas, including health boards. It is not the creation of an additional layer of meaningless bureaucracy. Rather, it would be as an active reviewer, an interrogator of risk, strategy and delivery of culture and governance improvements, providing checks and balances in a way that evidence to the inquiry has demonstrated did not happen and has not yet happened. It is also to ensure that nothing even similar to the Horizon scandal can ever happen again, whilst securing the future of the network. As has been heard through the inquiry, there has been a failure over many years and across different board members, chairs and senior management to either identify risks or ask questions which would have identified risks to the business and might have avoided this scandal, and thereby prevented it from getting worse. Postmasters invest in the network via their retail businesses, which host post offices. However, their ability to understand or feed into the short or long-term strategy of the Post Office is limited, as is that of the public, who are the ultimate owners and users of the Post Office. As mentioned, for the NFSP, there remain questions over whether government as a shareholder and the Post Office as the operator can, on their own, make effective changes in governance and culture and ensure the oversight necessary for proper safeguarding of the investment postmasters make in the network, or not to act in a manner that is not actually a detriment to the investment of postmasters. It is therefore the aim of this proposal of the Oversight Committee to bring together people with specific Post Office knowledge alongside those from a wider social perspective to ensure the social purpose of the Post Office remains key. The relationships between Post Office, government and representative bodies and consumer groups need to be repaired following the damage done by the Horizon scandal and the cultural and governance failures which led to it, as well as the ongoing failure to transform culture and governance. It's true to say that the reputation of the Post Office has been severely impacted by past and present events. The Oversight Committee is proposed as a way of repairing the relationships, restoring public and postmaster trust in Post Office. The preferred option in terms of ownership of the Post Office, as I've said, is via mutualisation. However, the financial stability of the Post Office must be secured first to ensure that is feasible. The secondary aim of this proposal, therefore, is to provide the ground for mutualisation. I'd like to call up a document if I can. That would be NFSP 00001481. Thank you. If we could scroll down, I'll say when to stop. And keep going. Keep going. There we are. Sorry, if you could just go back up. There we are. Current postmaster representation. Notes there the two formal representative voices for postmasters holding contracts with the Post Office, being the NFSP and the postmaster NEDs. Current postmaster views of the post office, a 9% decrease on postmasters feeling valued as a business partner of post office, 14% decrease on how supported postmasters feel by post office, and a 12% decrease in the number of postmasters who believe post office were genuinely trying to improve the relationship. If we just can scroll down further on postmaster earnings. In 2024, postmaster perceptions of the post office continued to erode as found via the YouGov postmaster survey for the inquiry. 48% felt dissatisfied with their role as postmaster, 72% reported feeling undervalued by Paul, 74% disagreed that Paul Board understands the concerns of postmasters. Now, if we can scroll on a couple of pages, please, and stop at key aims. There we are. Key aims to review, where relevant and appropriate, challenge the strategy of Post Office, identify potential risks and interrogate those risks, enhance the role of government as the sole shareholder, ensure government uses its powers to improve the culture at the Post Office, ensure the Post Office IT system is externally audited, demonstrate that a diverse group of people with a range of interests in the success of Post Office can work together. If we just scroll down to the role of the Oversight Committee, that would be due diligence takes place before key decisions are made, policies and strategy being implemented as intended, key risks identified and monitored, business processes and systems working well, expected results being achieved, value for money being obtained, activities comply with policies, laws, regulations, and developing areas of concern are dealt with. I'll just scroll down again to the committee makeup, committee membership. Thank you. Charity Governance Code proposes that boards should comprise between 5 and 12 people. It's said here 12. The makeup being government, DBT, civil servant 1, membership bodies, the NFSP, CWU, Unite, and external legal representation, representative bodies for older people, those with disabilities, the rural network, economically deprived, the consumer champion. Now, if we just scroll to the next diagram. Thank you. And that shows how that committee would be made up. And just scroll down one more page to what the Oversight Committee offers. So what does the Oversight Committee offer that isn't currently met? Preparation for mutualisation, ensure transparent distribution of subsidy, ensure the future viability of the network, offer a solution to any findings to be shared by your report, sir, scrutiny of daily running of Post Office to protect the investment made by postmasters, invaluable insights from those at operational level, and ensure the principles of public life. So I can take that down now, thank you. The Oversight Committee does not seek to take the ownership of or control of day-to-day operations. Instead, it's to include a scrutiny function between the board and government as seen in diagram 3, a check and balance. It is straightforward. Those participating come with knowledge, experience and background. It is not meaningless bureaucracy. It might be the inquiry considers such a committee can be adjusted to fit its own recommendations, sir. It might be the inquiry considers such a committee has a limited life while things get onto the footing that Dame Sandra envisions. Whatever it is called and however it exactly would work, it is the submission of the NFSP that at the very least something independent of the current stakeholders is absolutely required for the inquiry to answer questions E and F in the terms of reference positively. I'm going to move now from the present and the future to look at the past. Before moving on to look at representation and the roles of the representative bodies of the past, another aspect of the present Post Office is concern in the way it has conducted reviews of key issues such as past roles, Project Phoenix and Project Bolland. In past roles, the NFSP has previously raised concerns about Post Office employees who were part of the Post Office in the Horizon scandal years, however culpable or otherwise they were or were not, and are now in roles that are postmaster facing or affect postmasters. The NFSP wrote to the then Postal Affairs Minister Kevin Hollinrake on 8th January and said, "We're not confident that the correct review has or will be taken. Various individuals within the Post Office who have had past roles in the Post Office continue to hold, or held until recently, postmaster-facing roles, including Roderick Williams, who provided legal advice to the senior management team and was until recently involved with the remediation unit. Tracy Marshall, who appears to have had at least some knowledge of remote access when passing information to Angela van den Bogart, and is current Retail Engagement Director with responsibilities for postmaster onboarding and postmaster training. Nick Beale, Head of Network Development, which includes the NBIT project, we've already spoken about that, and who gave evidence on behalf of Post Office to Mr Justice Fraser in the GLO and was criticised. Martin Edwards, who was Paul Aveno's Chief of Staff and, for instance, was seen in emails back in 2013 looking at how the second site interim report could be spun to Lord Arbuthnot. He is now Network Strategy and Development Director, and the NFSP understands that despite his previous role as Paul Aveno's Chief of Staff and the evidence this inquiry has seen, Martin Edwards has responsibility for the strategic review and will be part of its implementation. The NFSP considers it completely inappropriate that someone involved in the Horizon scandal is now in charge of implementing the plan for the post offices and the postmaster's future. In addition, the NFSP raised past roles with Post Office when it transpired Post Office were intending to send individuals with past roles and whose names had come up in the inquiry to the NFSP's annual conference this year, and Mr Greenhow had to write to the Post Office asking them not to send individuals, including Tracy Marshall. It appears the Past Roles project only came about due to the inquiry's compensation hearings in December 2022, in which it became clear Post Office had recruited people into the remediation unit. That was 3 years after Lord Justice Fraser's judgment. The question arises why in the near present day was it ever considered appropriate for such people to be allocated to the remediation unit in the first place? There has been reference to the untouchables. Added to these issues, the inquiry has heard evidence there are some within the Post Office who are said to be considered untouchables, including investigators, the legal department, individuals within the legal team and the retail team. This is potentially as a matter of culture within the Post Office, but at the very least said to have been referred to as such by Nick Reid, although he considered he had not used this term. Mr Ismail, Mr Elliott, Mr Staunton and Ms Burton all gave evidence to this inquiry indicating that it was a term used. Putting to the side that the recent history of the Post Office should mean that absolutely no one is above investigation or accountability, the NFSP questions whether there's a possibility that the approach taken to the Past Roles project or Project Phoenix was influenced by an idea that some of those involved in the projects were untouchable. Project Bolland, another major failure to identify where has the money gone. That is in reference to the millions recovered and paid by postmasters arising from shortfalls in the Horizon years. The Post Office project to investigate this, when asked where the money went, former Financial Director Alistair Cameron said the question should be asked of Mr Reid. Mr Reid, in his evidence, suggested a figure of 36 million. The NFSP is concerned that the issues of wrongfully obtained recoveries may fall into obscurity and that without the scrutiny of this inquiry it may not be kept on the agenda. The NFSP has been calling for a full investigation into the wrongful use of the sub-postmaster contract, which required shortfalls to be made good only where error, negligence or carelessness on the part of the postmaster had taken place. That excludes Horizon and all that we know about it. At a recent meeting which the NFSP had with the Lord Advocate in Scotland on the 12th of December, they raised the issue of whether any criminal offences may have been committed by Post Office personnel in enforcing the postmaster contract for shortfall recoveries based on Horizon, knowing that there were bugs, errors and defects in Horizon. It's now understood that this is something which will be looked at as part of the overall UK-wide Metropolitan Police investigation. In terms of knowledge, information and representation, the submissions for phases 5 and 6 for the NFSP made extensive reference to the past. As set out in full in the written closing submission, the NFSP and the current Chief Executive, Callum Greenhow, wish to take this further opportunity to recognise and apologise for the failings of the past. It's accepted that those failings meant there were members affected by Horizon and sought assistance who did not get the response or the support they ought to have done. It also meant that when information, the post office line that Horizon was robust, as fed over many years by the post office to government, courts, the media, the NFSP and many others, could not be true, was brought to the attention of the then General Secretary George Thompson. For instance, in the correspondence to the NFSP from Lee Castleton in 2009 and from Sir Alan Bates in 2012, which the inquiry has seen, it was not acted on in the way it should have been. Although this correspondence was not properly shared within the NFSP by Mr Thompson, he certainly should have given serious consideration to what was in that correspondence and at the very least started to question the Post Office narrative. It turned out Mr Thompson was not the person to fulfil that role. Instead of Mr Thompson forwarding the correspondence to the Post Office as rubbish, he should have strongly challenged the Post Office about the reliability of its claims that Horizon was robust, but he did not. And for that, the organisation of today is truly sorry. Although only 54% of those prosecuted were sub-postmasters and not all of them were members of the NFSP, and although a challenge from the NFSP would not have stopped the Post Office, as we have found through this inquiry, nothing and no one could stop the Post Office machine, it certainly would have offered some support to those affected. This is also so because the inquiry has heard that the Post Office and government were able to rely on Mr Thompson's support for the Horizon is robust mantra. Turning to the representative bodies, of which list of issues 49 to 60 as part of your inquiry, sir, being the CWU and the NFSP, the one thing the NFSP wishes to be clear to the inquiry and has included in its Phase 5-6 submissions, in terms of the start of Horizon's rollout in 1999, right up until the removal of trade union status in 2014, there was no difference at all between the CWU and the NFSP in the methodology for the representation of their members. Neither organisation did or does now provide legal funding or legal backing for criminal representation. Neither organisation at the time had any real method of local representation, with issues being fed back up the line to HQ. Both organisations did not know about those members who resigned or left their post quietly without seeking help. Neither organisation had information coming through to it which showed a pattern of prosecutions. Both organisations described regularly feeding back to the Post Office. For instance, Colin Baker of the NFSP and Tony Cairns of the CWU did this, describing in their evidence to this inquiry about what they understood were teething problems and glitches. As Tony Cairns said, it was not for them to look under the bonnet. The assurances given to them by the Post Office were taken at face value by both organisations. It submitted the inquiry can find there were no real differences between the NFSP and the CWU in the way in which they were organised and undertook their representation of members on the ground. The NFSP's written closing submissions note the difficulty the inquiry may have being able to scrutinise the CWU's role in terms of question 49, or list of issue 49, due to the lack of available information from it, as apparently it knew nothing, didn't hear from its members about Horizon despite thousands of them using it every day. Anyone charged with a criminal offence would have been dismissed or resigned and would no longer be a member, and so wouldn't have contacted them, according to the witness statement of Andy Fury. The inquiry will also have seen the CWU's brief written closing submissions, which says that failed representation of the past means there should be an independent trade union for postmasters, and this should be recommended by the inquiry. The NFSP considers those submissions do not show insight into the failure of the model of representation which both organisations operated at the time. There appears to be no look back, no information about how it has changed its representative model. By contrast, it submitted through the evidence provided in the witness statement of Callum Greenhow the documents including the updated grant funding agreement with the much criticised clauses removed. The ongoing public criticism of the Post Office by the NFSP demonstrates that the CWU's submission on the NFSP is simply out of date, focused on the past and not the present. It submitted that the evidence of Callum Greenhow in his witness statement and to this inquiry demonstrates real learning and a very wide set of changes made since the Common Issues judgment. The NFSP wishes to assure you, sir, that it is committed to representing its members' views and is not afraid to challenge the Post Office when that's in the interests of its members. It submitted the NFSP has demonstrated this through initiatives such as the training of branch officials, the introduction of the advocacy system, information gathering monthly and reporting from branch officials for board meetings to identify patterns and issues, helping members with the Horizon Shortfall Scheme and identifying suitable legal support, meeting with and campaigning on diverse issues from hard to place, remuneration, failure of network transformation, the historic systems of Capture and Echo Plus, and much more. Introduction of its own whistleblowing and complaints policies. The campaigns with the other jurisdictions and the quashing of convictions. The NFSP is pleased to report a very useful meeting with the Lord Advocate and Cabinet Secretary of Justice for the Scottish Government. As I mentioned, it took place last week, and a lot of work is clearly being done to identify past victims and also with involvement with the Metropolitan Police into potential criminality. As was said, the question is asked, if you can't trust a senior in-house solicitor and a senior barrister when they tell you they have looked at all past prosecutions and it's okay to continue with prosecutions, then who can you trust? It submitted it was reasonable for the Crown to believe what they were told, just as it was reasonable, subject to the caveats I've mentioned earlier about Mr Thompson, for the NFSP over many years to believe what it was told, certainly in the early years, about Horizon. The NFSP is an organisation today which has looked at an in-depth way to understand what went wrong and to change it and marry that up with what works well. It submitted that as a measure of an organisation which has insight. It has updated, reformed and adjusted where necessary, while continuing to campaign and noise up where necessary the Post Office. It submitted that nothing has been seen, heard or done in the time of this inquiry that could allow the inquiry to find that the NFSP today is some sort of puppet or patsy for the Post Office. It is not. It is submitted that it is vital that a large and strong organisation, which the NFSP is, remains very firmly on the map for postmaster representation. It is even more vital when it appears the Post Office seeks to divide the postmaster groups, appearing to consult or take views into account, but in a way that waters down actual campaigning and challenge. The NFSP asks the inquiry to take into account its submission on the relevant timelines as set out in its submissions on Phase 5 and 6. That was done in some detail in the submission, sir. I would ask you to take that into account. There's not enough time to go into all of that now,
Sure.
But it's there. In particular, where each event sits in the history between 2000 and 2016, the trade union status, network transformation, the coming into being of the GFA in July 2015. It submitted that things have moved on so much and so much has been done and changed that much of what has been said about these matters is time limited and now in the past. Right now it's submitted that the thousands of postmasters who are members of the NFSP need such a body with its structures, experience and knowledge to represent them. Informal groups of a few hundred here and there have no funding, no structure, and the danger is they could ultimately be used by or subsumed into the corporate structure via, for instance, the Postmaster NED role, the Postmaster panel role, which ultimately weakens rather than strengthens the ability to challenge. It may be complementary, but it weakens the ability to challenge. It is something of an irony that the organisation criticised by Lord Justice Fraser is today the organisation which actually can and does challenge the Post Office on so much and campaigns on so many issues affecting postmasters. For the NFSP, it is an organisation of the now and the future. It has looked, learned and adjusted, and it is the true voice for today's postmasters. In concluding remarks, sir, it's submitted that the postmasters in the Post Office network deliver an essential service. This service should be valued and promoted. Although the Post Office has broken every element of trust that there ever was, there has to be the hope that it can be saved for the public who need it. The NFSP say the Post Office should not be closed down. Postmasters have invested in the network. It serves communities, vulnerable individuals and the public at large. Those people have invested their funds, their time, their families and their lives into this. It submitted that it's time the government, DBT, UKGI and Post Office itself honours that investment and acts properly, with proper oversight put in place, bringing back the trust the public and the postmasters so want to have in it. In closing these oral submissions, sir, the NFSP turns back to the theme of hope. It hopes that the simple truth is there is some good in this network and that it is worth fighting for. It is a good that every postmaster upholds when they make the choice to invest in the post office network and serve their communities every day. It is a good felt by the most vulnerable groups in our society, and it is a good that if it is removed will not be brought back. The good that is brought into this society by the service of postmasters and others within post office branches must be valued and must be protected. Postmasters, including the NFSP's members, feel real pride in serving their communities, and they should be enabled to do so in a way that rewards their service. The NFSP has faith in the findings of this inquiry that it will help to realise the vision and protect the service of so many hard-working, public-minded individuals across the country who have been let down and undervalued consistently for decades. While the inquiry has heard much of the can't remember, can't recall, I don't remember seeing that, I don't remember reading that, I don't remember receiving that, and so on and so on, the documents interrogated by this inquiry give the lie to that. As Robert Burns famously said in his poem, A Dream, facts are chiels that winna ding and downa be disputed. Translated as, facts, and therefore the truth, can never be denied. Sir, it is a big ask, a huge ask, but the hope of the postmasters of the past, the postmasters of today, and the public now resides with you. Thank you.
Thank you, Ms. Watt. Right, so we will break now and have 15 minutes. I think if we start just after 20 to 4, Mr. Sheldon, and then we'll continue until you've used up your time. I think the door has been closed, so if we'd all now be quiet so that Mr. Sheldon can make his submissions.
So thank you. As you are aware, I act for UK Government Investments, UKGI, in this inquiry, which is grateful to you for giving us the opportunity to make these closing submissions at the end of your hearings. I'm very conscious that I'm delivering them at the end of a long day, and I would wish to reassure you and indeed everyone else that what I'm going to say I will say as concisely as possible. I last addressed you, sir, in October 2022 by way of an opening statement which was accompanied, as you may recall, by a lengthy set of written submissions which sought to set out in as much detail as possible the nature of the role played by UKGI and its predecessor organisation, SHEGS, an analysis of the chronology by reference to what we perceive to be the key milestones, and UKGI's reflection on its performance. So those opening submissions and the witness statements we have provided to the inquiry for the purposes of phases 5, 6 and 7, which we sought to make as detailed, precise and comprehensive as we could, set out our account of what we did not do, and what we should have done better. In both our written evidence and the oral evidence of those witnesses from whom you have heard, we have endeavoured to be frank and self-critical, and we hope you have found that evidence to be of assistance. So we have now provided you with an equally lengthy set of written closing submissions, and in those submissions and the brief observations I propose to make this afternoon, we have not sought to repeat or reanalyse the chronology of our involvement. You have our evidence as to what occurred, and you will, of course, reach your own conclusions on that. We have instead sought to focus primarily on the present situation for the purposes of addressing head-on some of the issues of concern we anticipate that the inquiry may have having listened to the evidence in phases 5 to 7. We've sought to explain how we have addressed those issues, and we have provided, we hope, some reassurance that the lessons of this scandal have been learned, at least from UKGI's corporate governance perspective. Before I turn briefly to look at some aspects of that analysis which we would submit are of particular significance, it's right that I deal with two matters of fundamental importance at the outset. The first is to address directly the purpose of the task with which we are all engaged. So you do not need me to tell you of the utter devastation that this scandal has caused to the lives of postmasters and their families. You have heard from them directly, and you have heard eloquently from their representatives today. They also, I suspect, will have little time for yet further expressions of sympathy from yet another institution that had the capacity to do more to at least potentially prevent some of the harm that they have suffered. But it is important that I provide you and everyone else with an interest in this inquiry with the reassurance that throughout this process, we have not lost sight for a moment of why we are here. UKGI's board, our chief executive, Charles Donald, who has spent many days in this room listening to the evidence, our witnesses, the team at UKGI that have been supporting the work of the inquiry, and its external legal team, all of us, have had at the forefronts of our minds throughout the responsibility we have to postmasters and their families who have been affected by this scandal, and the overriding imperative to ensure as far as humanly possible that nothing like this ever happens again. And that obligation has informed every witness statement, every set of submissions, and every decision that has been taken in determining our approach to this inquiry. As to how that obligation is to be discharged by a responsible public body, I can only repeat what I said to you in our opening statement. A responsible public body must give a full and frank account of itself at the earliest possible opportunity. It must provide the investigation with complete and unequivocal cooperation. It must be objective and self-critical in its evidence, and it must remain open-minded and willing to learn lessons throughout. So we stand by those obligations, and we acknowledge that we should be and will be judged by them. Secondly, whilst the rest of what I'm going to say is going to be directed primarily at the future and the present, I need to deal with what has happened in the past to at least this extent. As we anticipated in our opening statement, it seems to us that the evidence you have heard has borne out the conclusion that there were governance failures relating to Horizon in which UKGI and its predecessor SHEX played a part, and for which it must therefore bear its share of responsibility. There were times when we were too accepting or trusting of assurances given by others as to the integrity of Horizon and the baselessness of legitimate postmaster concerns. There were times when there were opportunities to effectively challenge such assurances which were not taken. There were times when investigations were started which might have led to the true position being identified much earlier, but they were not followed through. There were times when advice was given in relation to Horizon which lacked sufficient objectivity and failed to make clear that it merely reflected what we had been told by the Post Office. We have read with care the closing submissions of the other core participants, including those of the department. In some respects, the criticisms made of SHEX and UKGI reflect our own analysis, which I've just sought to summarise. In other respects, we would disagree for reasons that are addressed fully in the witness evidence of the individuals concerned, which we know you will consider with care. But we have sought, as an institution, and through our individual witnesses, to be as frank and objective as we can in identifying where we fell short, and we have no intention now to start engaging in an exercise of blaming others or avoiding responsibility. Corporate governance may often be thought to be a dry and rather esoteric subject of interest to company directors, but perhaps not many others. However, corporate governance goes to the heart of what we do, and we have devoted a great deal of energy on assessing where corporate governance for the Post Office could and should have been delivered more effectively. I doubt there has ever been a clearer example in the history of this country, at least, of the real-world impact on people's lives if corporate governance is not delivered effectively and well. Having reflected on our role very carefully, it seems to us to be clear, on the totality of the evidence you have heard, that at critical junctures we should have provided more robust challenge, and had we shown more curiosity, the legitimate concerns raised by postmasters and their representatives may have been given more weight. For that, sir, we apologise unreservedly. Nonetheless, it is also important that I make clear that there is no suggestion in the reams of evidence and millions of pages of documents that are before the inquiry of any SHEX or UKGI employee ever having deliberately sought to victimise postmasters, hide the truth, or engage in any form of cover-up. The failings which we have acknowledged and for which we apologise, significant though they were, resulted from a lack of curiosity and/or objectivity. There is no evidence whatsoever of any SHEX or UKGI employee being aware of defects with Horizon that they sought to conceal, deny, or obfuscate. There is no evidence whatsoever of any UKGI or SHEX employee being aware of a wrongful conviction that they sought to conceal, deny, or obfuscate. And there is no evidence whatsoever of any UKGI or SHEX employee deliberately providing information they knew to be misleading or seeking to hide the truth. No such allegations have been put to any of the SHEX or UKGI witnesses from whom you've heard, and there is no support for them in any of the evidence before the inquiry. UKGI itself has found no evidence for such suggestions. If we had, we would have told you. The answer to the question of whether SHEX and UKGI should have reached a better understanding of the nature, scale, and implications of the Horizon scandal sooner is undoubtedly yes. The answer to the question of whether UKGI and SHEX or any of its employees deliberately sought to suppress evidence of that scandal is unequivocally no. So, having dealt with those two important preliminary matters, can I turn to the focus of my submissions this afternoon, which is on the way in which UKGI now seeks to deliver effective corporate governance oversight as a shareholder representative to the assets in its portfolio, and the Post Office in particular, and the ways in which we have sought to address the historic shortcomings which the evidence given to this inquiry has helped to identify. So the first submission I want to make in this regard is that the shareholder model or framework within which UKGI seeks to provide effective corporate governance oversight to complex arm's-length bodies such as the Post Office, which has evolved in a number of important respects since 2012, is fundamentally a sound one. I won't deal this afternoon with the rationale for the existence of arm's-length bodies, which, as you know, there are over 300 across government, and which have been a feature of the government landscape for over 50 years, nor am I going to set out the reasons why government departments consider it appropriate to outsource the shareholder responsibility for the most complex of those arm's-length bodies to a specialist organisation, such as UKGI. We've dealt with all of that in our written submissions, and you've heard evidence from a number of very senior and experienced witnesses as to why individual departments require the specialist corporate governance and corporate finance expertise of a body such as UKGI for those complex assets. I'm going to focus, if I may, on the more difficult and we would submit pertinent question of how effective corporate governance should be delivered within that model. Put simply, how should the system operate and who is responsible for doing what? In seeking to express this as clearly as possible, and I accept that there have been times during the evidence where it has seemed perhaps unnecessarily complicated, we'll gratefully take the lead from your corporate governance experts and describe the way the process is supposed to work by reference to the 3 levels of governance and how they are supposed to operate when a problem like Horizon comes along. The first level of effective corporate governance is frank, accurate, and honest reporting by the executive to the board. It is a fundamental requirement of responsible management that when you identify a problem, you provide an honest and accurate account of that problem to the board, and the culture of the company must encourage that approach. The second level of effective corporate governance is professional curiosity and challenge by an engaged, proactive, and suitably skilled board. The board is obviously entitled to expect that it is receiving a frank and honest account from the executive, but it still has the responsibility to question, challenge, and test what it is being told. Where necessary, it can call for further information, it can direct the executive to do further work, it can commission investigations of its own. There are a range of tools available to the board to get to the truth of the matter, and if it has any concerns about the accuracy of the information with which it is being provided by the executive team, it must use them. The shareholder non-executive director, as a member of the board, must play his or her part in ensuring that that is done. The third level is that of the shareholder, in this case the Department for Business and Trade and its representatives, namely the shareholder team within SHEX or UKGI, with responsibility for the asset. It's important to note that SHEX was a directorate of the department until UKGI was formed in 2016. When things are working as they should, both the department and the UKGI shareholder team will have good visibility of the operation of the company, including how it is dealing with significant problems or difficult issues, through frequent interactions at a variety of levels, ranging from meetings between ministers and the chief executive or chairman, down to day-to-day contact between members of the shareholder team and their counterparts in the company on a whole range of issues. It is through this interaction that the department or the UKGI shareholder team deal with the way or become aware of the way in which issues are being dealt with by the company. And if they're concerned about how that is being done, there are a number of things they can do about it. They include, as you have heard, escalating the issue within UKGI up to the chief executive and, if necessary, the board, and escalation with the potential for direct intervention by the department, including by the minister. However, sir, it will be immediately obvious that the effectiveness of this level of governance also depends upon the reliability of the information that is being provided by the company as to the nature and extent of the issues, and the willingness of the shareholder team and the department to challenge and interrogate what they are being told. It's also self-evident that if a proper understanding of the problem is not grasped at levels 1 and 2, the management and the board, it is going to be very difficult to do so for the first time at the third level. Now, that is not to say, of course, that the third level of governance is not important or that its effectiveness should not be optimised. Operated properly, it provides a vital opportunity to identify governance shortcomings at levels 1 and 2 and to take action to address them through the variety of means that we've described in our written submissions. And in particular, sir, in this regard, we would respectfully disagree with the witnesses who have suggested that ministers lack the power to act in circumstances for the purposes of directing how the company should approach an issue such as Horizon. There are, and there were at the time, a suite of hard and soft powers available to ministers, ranging from the power to dismiss the chairman contained in the articles and exercised recently to remove the former chair, to issuing of the annual chair's letter, to the power to call in the chair or the chief executive for a meeting to provide direction, as was the case when Baroness Neville Rolfe commissioned Mr. Parker to undertake his review. It may be that the full range of these powers was not clearly understood by all of those in office through the relevant period, but there is no doubt that those powers existed and continue to exist, and the chronology shows examples of them being used effectively. In short, therefore, sir, we submit that there is nothing fundamentally wrong with the underlying governance model in place for complex government-owned assets such as the Post Office, and we would agree with the submissions of DBT in this regard. It is a well-developed model. It is applied to a large number of complex commercial assets across government, and it has the potential to operate successfully, provided, of course, that those involved at each level effectively discharge their responsibilities. That being so, the focus of UKGI's reflections and the analysis of how we ensure that the failings evident in relation to Horizon are not repeated has been on how to promote good practice at each of those three levels of governance, so that if issues of the type that arose in this case were to arise again, whether in the Post Office or in any of our other assets, they would be identified and properly dealt with before they can cause the type of damage we have seen here. So as you will have seen, the greater part of our written closing submissions is directed to that issue. And there is no value to be gained from me trying to summarise 90 pages of analysis in 30 minutes or so. What I would like to do, however, is to provide a short overview of the work that has been done by UKGI over the last 5 years or so, some of which has been directly in response to the Horizon scandal, and how that is intended to fit together in a coherent and comprehensive way to ensure that the governance framework I've just described is operated effectively. So before I deal with that, can I just pause to make these two important points which set the context for what follows. First, it is not the role of a shareholder body such as UKGI, or indeed the shareholding department, to run the company. That's the job of the company's management, overseen by the company's board. And as I've touched on, there are good and obvious reasons why that should be so. Nor is it the role of the shareholder to act as a shadow board or a shadow executive. The measures that I'm just about to describe, the operating principles, training, guidance, evaluation, and so on, are not designed to equip UKGI's shareholder non-executive director, all the shareholder teams, to run assets or second-guess the executive, but to put them in the best position possible to assess the performance and culture of the company, identify issues facing the company when they arise, and support the company in dealing with those issues effectively and appropriately. Secondly, sir, we would wish to emphasise that UKGI is committed to remaining a learning organisation which seeks consistently to evolve in order to incorporate developing corporate governance standards in its practice. Whilst we seek to reflect current best practice in our operating principles and guidance, we recognise that delivering effective shareholder oversight of a complex company, which is not providing a full and accurate account of the difficult issues it is facing, is a very challenging task. The history of corporate scandals is sadly littered with examples of high-powered and experienced boards failing to detect or address what turned out to be a devastating problem. As you have heard, the board of the Post Office included over a period of many years, highly capable and experienced individuals who failed to understand fully the scale and impact of the Horizon problem. Same obviously applies to the SHEX and UKGI shareholder teams and the department. You've heard many of them say that they would have positively welcomed a clear answer to the question of the reliability of Horizon and the resolution of the dispute with postmasters, regardless of which way it went. And yet it took the litigation to uncover what, on any view, should have been revealed much sooner. So, in reflecting on this scandal, the one lesson that has been driven home to UKGI, above all others perhaps, is that it has to continually reflect and enhance how it performs the shareholder role for organisations in its portfolio and identify strategies to ensure that it can support those organisations in identifying issues early and take appropriate action in response. What we have sought to provide you with, sir, and what I'm about to briefly describe, is where we have got to thus far in that process. But we acknowledge that there will always be more to do, and the findings of this inquiry will inevitably play an important part in that work. Turning then to the first level of corporate governance and the fundamental requirement of an open, no surprises culture of frank reporting, the focus of UKGI's attention has been on ensuring that we more rigorously and actively assess the culture of an organisation from a shareholder perspective. Horizon has brought home very clearly how vital this is. There should never be circumstances in which the executive feels able to be less than frank and open with the board, or to withhold important documents which illustrate the true position. If they do, then the corporate governance framework will be very seriously undermined from the outset. We identified this issue as one of the 5 key reflections in our internal review, and we have reflected on it further over the course of this inquiry to identify how best we can ensure that deficiencies in the culture of a portfolio asset can be quickly identified and addressed. As we set out in our written submissions, there is now a clear emphasis on the importance of corporate culture that runs through UKGI's training, our guidance and our operational processes. And UKGI's shareholder non-executive directors and shareholder teams understand that it is a central part of their role to monitor and report on the state of the culture within their assets, and to take active steps to encourage and promote a healthy corporate culture. This is done at board level by the shareholder non-executive director. It's done through the shareholder team's interactions with the chair and the senior executive, including at quarterly shareholder meetings, where the Post Office corporate culture is now a standard agenda item, and it's done through monthly ministerial meetings involving the Post Office, UKGI and the department. Activity 1 of our portfolio operating principles, to which I'll return in a moment, directs that UKGI shareholder teams should seek to promote a healthy corporate culture within the asset and ensure that the asset develops appropriate metrics and reporting on cultural issues. And we have developed internal guidance and training to assist shareholder teams and non-executive directors in effectively supporting and challenging our asset boards to address cultural challenges. They set out the specific actions that the non-executive director and the team should undertake in relation to culture, providing practical guidance as to positive and negative indicators that boards should be monitoring and how the shareholder team should seek to encourage these activities. We encouraged the appointment of postmaster non-executive directors to the board of the Post Office, and we continue wholeheartedly to support that initiative. The annual chair's letter emphasises the importance of maintaining a healthy corporate culture and sets out clear expectations in this regard. So that's a brief summary. It's by no means a comprehensive one. The key point that we would wish to convey is that this lesson the fundamental importance of carefully monitoring and assessing the corporate culture of a portfolio asset and ensuring that that vital first level of corporate governance is effective has been well learned, and a wide range of measures implemented to ensure that if an unhealthy corporate culture starts to develop in an asset, it is quickly identified and robustly addressed. As to the second level, sir, professional curiosity and effective challenge by the asset board, we've developed a range of measures designed to support asset boards in being more robust and more effective in this respect. This is an area in which we would respectfully suggest the problem's quite easy to articulate, but the solution is much more sophisticated and multi-layered. So we don't seek to preempt your conclusions in any way, but it seems to us clear that there were points in the chronology where the Post Office Board did not display adequate curiosity or apply adequate challenge, or when it did, it failed to follow through with investigations it had set in train. Now, a board inevitably relies in the first instance on what it's being told by the executive and the material with which it's provided. It will justifiably place a degree of trust in that information. But it can ask questions. It can demand more information. It can direct the executive to undertake further investigations. It can commission independent insurance exercises itself. And the Horizon chronology contains periods in which that was done. Examples include the board's demand for a comprehensive programme of remedial action in response to the Second Sight interim report, once the initial concerns about the handling of the process had been addressed. That's one example. The commissioning of the independent assurance work by Linklaters and Deloitte is another. But there are other examples of where the curiosity and interrogation was limited, including the Second Sight thematic report and the Panorama broadcast. Detailed refutations were prepared by the executive and considered by the board with little, if anything, in the way of challenge. And in the final analysis, there is simply no getting away from the fact that the board never demanded or commissioned a full, drains-up review of the Horizon system of the type it ultimately took the litigation to deliver. So how do you ensure that a board faced with an issue like this in the future is more curious, more challenging, and more ready to do whatever is necessary to get to the bottom of the matter? Now, UKGI has reflected very carefully on that, and from our perspective, there are three central elements to the answer to that question. That is to say, three key ways in which UKGI can seek to promote high standards of curiosity and challenge on the boards of its assets. The first is ensuring that the board is subject to a regular and thorough process of evaluation. Our portfolio operating principles now set a clear requirement for board effectiveness reviews to be conducted every year, with every third review undertaken by external reviewers. That requirement is reinforced in the Chair's letter, along with the requirement to involve stakeholders, including the government, in the process. The reviews must include board composition, risk management, the overarching culture and tone of the board, and the clarity of leadership it gives to the company. Our portfolio operating principles also require a separate appraisal process for the Chair, in addition to the board effectiveness review, and for the evaluation of the performance of individual non-executive directors. The second, sir, is the establishment of a clear set of specific requirements concerning information flow into the board and the circumstances in which the board should seek its own independent assurance of what it's being told. As to the former, sir, you will have heard a number of times from a number of different witnesses that legal professional privilege was used as a justification for failing to provide important information to the board. It is now made crystal clear that LPP will not provide a proper reason for withholding any information from the board, and this has been expressly written into the framework agreement that covers the relationship between the Post Office and the shareholder. As to the latter, the portfolio operating principles deal expressly with the importance of a board commissioning its own assurance work, and also make clear that this is a tool available to the shareholder as well if it has concerns as to the accuracy of information with which it is being provided. So you've seen some evidence of the operation of these principles in relation to the current project to replace Horizon and the commissioning of external assurance work by the board, including the recent instruction of Accenture, and by the department as well, through the engagement of Public Digital and the Infrastructure Projects Authority. So the third way we seek to achieve this objective now is the development of a suite of good practice guidance to help provide UKGI shareholder non-executive directors and their teams with a set of standards by which the quality of a board's processes and procedures can be assessed. So I don't have time to deal even in summary with all the relevant aspects of this guidance this afternoon, and it's all set out in our written closing submissions and the documents we've referred to. But I would just take a moment to deal with one issue of particular relevance and importance, which is whistleblowing. So as you may recall, this was an issue that was identified as requiring careful attention in our internal review, and we dealt with it at some length in our opening statement. The position now is that our portfolio operating principles expressly require shareholder teams and shareholder non-executive directors to ensure that the assets whistleblowing policies and procedures are adequate and effective, and there is a detailed set of guidance which identifies precisely what good practice looks like in this area, including regular reporting, analysis of how complaints have been handled, the role of the board whistleblowing champion, and so on. Both Tom Cooper and Lorna Grattan, in their Phase 7 witness statements, have described how the shareholder team has assessed the Post Office's procedures against those standards. And so in short, that model of identifying an express requirement on the part of the shareholder team in the portfolio operating principles to monitor and assess the information flowing into the board, backed up by a suite of guidance that makes clear what good practice should look like, provides a benchmark for the assurance process. That model is one that's been applied in the same way across a number of relevant areas, and I refer to whistleblowing simply as a representative example in that regard. So I turn then finally to the third level of governance, which is the level provided through the oversight of the asset by UKGI in conjunction with the relevant department, and the ways in which we've sought to improve our effectiveness at this level, with particular regard to the issues which we anticipate are likely to be of concern to you. So as you will have seen from the written submissions, there is again a lot of detail here, and I won't lengthen these submissions by attempting even a summary of all of it, but there are just 4 short areas I would wish to highlight as being of particular significance in the light of the evidence you've heard. The first is the development of our portfolio operating principles, which you will have seen were introduced in 2020 and have been updated on a regular basis to take into account evolving developments in corporate governance standards. In keeping with UKGI's reflective approach and desire to avoid recurrence of a significant failing such as Horizon occurring in its portfolio, the portfolio operating principles have also been significantly amended to incorporate further lessons and insights derived from our reflections on Horizon and our engagement with your inquiry. I'm very conscious that this may not be the most exhilarating topic to introduce at this stage in the afternoon, but its importance really cannot be overstated. The portfolio operating principles and the guidance that they incorporate amounts to nothing less than a clear, comprehensive and accessible codification of how UKGI should go about discharging its shareholder governance functions, which any member of any shareholder team can refer to whenever they are considering how best to deal with an issue. Everyone is trained against using them, and performance is regularly assessed against them. So you will have heard evidence from a number of witnesses at a variety of levels who have described having to navigate novel situations or deal with difficult issues at times without the necessary guidance to do so. UKGI has sought to address the thematic governance issues it has identified from Horizon to date and to evolve its processes accordingly. Whether the issue is whistleblowing, the commissioning of independent assurance of management information, the performance of the board, the performance of the executive, or effective engagement with the department, the correct approach will be found in the portfolio operating principles and the guidance embedded within them. So the second key element of this is an overhaul of the recruitment and training of shareholder non-executive directors and shareholder teams. In relation to recruitment, there is a clear emphasis on identifying and developing shareholder non-executive directors with the right balance of skills and backgrounds, including board experience and very often civil service experience as well. Lorna Grattan, the current shareholder non-executive director on the Post Office board, stands as a representative example of this approach. And to the extent that there may have been an impression in the past, fair or otherwise, of UKGI being solely staffed by investment banking deal makers with limited interest in corporate governance, that is emphatically not the case now. The organisation today is a broad church with civil servants, corporate restructuring experts, accountants, lawyers, consultants, all well represented, alongside those with banking and corporate finance experience. It's precisely this mix of skill sets, we would respectfully suggest, that enables UKGI to deal effectively with a very wide range of different assets, from the Nuclear Decommissioning Authority to the Ordnance Survey to the British Business Bank, as well as the wide range of government departments with responsibility for those assets. As for training, about which all our shareholder non-executive directors were quite understandably asked by your council, UKGI frankly acknowledges that there was plenty of room for improvement in this area, and as you've heard, this has been a particular focus for our chief executive since taking up post in March 2020. UKGI now has a learning and development leader who oversees an extensive programme of formal training for our shareholder non-executive directors and shareholder teams, supported by a variety of initiatives, including seminars run by experienced external chairs and a number of internal forums in which shareholder non-executive directors can discuss difficult issues in their assets and share experience. An understanding of and compliance with the Civil Service Code is treated importantly, forming part of the induction training for all our new joiners. Its significance for UKGI staff in the discharge of their duties is also emphasised in UKGI's internal code of conduct. So you will recall the evidence of those dealing with Horizon issues at particularly challenging points in the chronology, including 2015, to the effect that it was very difficult to see a solution or an effective way forward other than litigation. That generated a degree of frustration which had the potential to bleed into correspondence, submissions, and the approach to issues more generally. That is not an excuse, but it is at least a partial explanation. In light of that evidence, the benefits of the suite of resources now available to a shareholder non-executive director and a shareholder team in terms of training, guidance, and encouragement to test their understanding of how best practice might be applied to the issue in question, when to escalate their concerns, are obvious. So the third area I wanted to highlight briefly concerns the separation of the shareholder and policy roles. which occurred in 2018 in the case of the Post Office and is now the established model across UKGI's portfolio of assets. So as you've seen, one of the complexities in assessing the performance of SHEX and or UKGI over the lengthy period with which you are concerned is that the model was different at different times. The first shareholder non-executive, who was in post from 2012 to 2014, was not part of the shareholder team, wasn't involved at all in briefing ministers regarding the Post Office. Between 2014 and 2018, when the second shareholder non-executive director was in post, that director was also the head of the shareholder team and was responsible for briefing ministers, interacting with the department on both policy and shareholder issues. From 2018, roughly coinciding with the appointment of the third shareholder, Ned, the department set up its own policy team, leaving the shareholder team and the shareholder non-executive director to focus on shareholder governance issues alone. Now, it's that final model that UKGI has identified as the correct one. As to why this should be of any interest to you, we've attempted to articulate that as clearly as we can in our written submissions, but there are just two essential points. The first relates to the provision of advice to ministers. There were points in the chronology, particularly around 2015, when the issue arose of how directly the department should seek to involve itself in the Horizon issue and whether it should establish some form of further investigation. And you'll recall that some concern was expressed as to the nature of the advice that was given on that issue. It's fair to say that those concerns do not appear to have been expressed at the time, and that ultimately the Minister did commission a further investigation in the form of Tim Parker's review. But it is also fair to say that with the benefit of hindsight, those concerns are understandable. The problem in this context, which with respect, sir, we submit you correctly identified in some of your questions to the relevant witnesses, is that there is the potential for conflict between the policy and the shareholder roles when it comes to a difficult issue receiving public attention. Again, at the risk of oversimplification, the answer to the question of how best a minister should approach a difficult and controversial issue receiving critical public attention may well be different depending on whether you're approaching that question from a policy perspective or a corporate governance perspective. In relation to the former, it's understandable how advice relating to the operation of a company's IT system could be characterised as an operational matter for the company, leave it there. In relation to the latter, corporate governance, the correct approach may well be to shorten the arm in relation to the arm's length body and get directly involved in seeking a solution. So the final area I wanted to highlight is how UKGI and its shareholder non-executives manage conflicts of interest when they arise. UKGI recognises that there will be times when specific issues will arise in which the interests of the company and the priorities of the shareholder may pull in different directions. As you've heard, funding is one example, and others may arise from time to time. That said, it is important, we would respectfully submit, not to overstate the issue. Where a company is owned by a sole shareholder, substantive conflicts are likely to be rare as the views of the company and the shareholder are, more often than not, going to be aligned. Nor is this a situation that is unique to the Post Office or government-owned companies generally. Indeed, this is a challenge which is regularly grappled with by private sector companies and frequently within the public equity model, where it's customary to place a shareholder representative on a board. Where conflicts of interest do arise for shareholder non-executive directors at the board, however infrequently that may be, UKGI's view is that these are very manageable. For the most part, constructive dialogue will provide mutually acceptable ways forward. In some cases, formal recusal may be necessary, But even in that situation, the shareholder non-executive director will still typically be able to convey the views of the department to the asset board so that the shareholder's perspective can be provided to the board in their decision making. The issues that arose in the very particular context of the recusal application concerning Lord Justice Fraser were unique and do not, we would submit, reveal any inherent deficiency in the model. The inquiry will recall that at the time, given the uniqueness of the situation, the shareholder non-executive director sought and followed legal advice from the department's lawyers and acted in a manner which was consistent with the messaging received from the department. As with private equity funds companies, it is UKGI's view that the advantages of having shareholder representation on boards in terms of information flows and helping boards understand the priorities of shareholders generally significantly outweigh any potential disadvantages. So, sir, in addition to the guidance and training to which I have already referred, UKGI has given careful thought to how the structural issues that have been exposed by the evidence relating to at least some of the parts of the chronology should be addressed. The role of the shareholder non-executive director and the shareholder team when dealing with a difficult and intractable issue within an asset are now very clear. So that's all I intend to say for the purposes of highlighting what we consider to be some of the most relevant aspects of the work that has been done since the events that you've been examining in phases 5 and 6. There's much more in our written closing submissions which we know you'll consider in full, but we hope that we have provided you and all those concerned with some reassurance as to the nature and extent of the progress that has been made. As for phase 7 and the Post Office today, UKGI has an important role to play in the future of the company. We need to support it, provide a critical shareholder oversight role, and act as an interlocutor between the company and the shareholder. The structures that are now in place in UKGI for delivering on those objectives are essentially sound, and you have heard from our current shareholder non-executive director and chief executive how they're being operated. The effectiveness of the Post Office board is being regularly assessed and now seems to be heading broadly in the right direction. There is good visibility of the company's operations on the part of the department and the shareholder. The lines of communication are effective. There is frequently challenge and interrogation of information. However, whilst that may be the state of play from a corporate governance perspective, there is no avoiding the fact that the Post Office continues to face significant challenges in delivering substantial and tangible improvement in its relationship with postmasters and embedding a corporate culture that treats them as valued partners working towards a common set of objectives. UKGI is committed to doing all it can in supporting the company to overcome those challenges, and if the inquiry identifies ways in which it considers that that can more effectively be done, we will of course be very receptive to any such guidance and direction. So just finally this, I am conscious, acutely conscious, that it is not uncommon for institutional core participants to stand up at the conclusion of an inquiry of this nature and assert their unwavering commitment to the learning of lessons and how much they are looking forward to receiving the inquiry's recommendations. The understandable reaction to any assertions of that sort will obviously be they would say that, wouldn't they? In my submission, what an inquiry will expect to see from an institutional core participant at this point in the process, and what the public, and most importantly, those directly affected are entitled to see, is that the institution has not sat around waiting for the inquiry to tell it what to do, but has got on with the task of working out what went wrong, identifying the changes and improvements that need to be made to ensure that it doesn't happen again, and implementing those changes. So as you've heard, UKGI started a formal process of reflection and learning lessons in 2020. In our opening statement in 2022, we sought to provide you with a progress report on the work done at that point. We've sought in our closing submissions and in the brief summary I've sought to give you this afternoon to provide you with a further update. We are acutely conscious that we cannot undo the mistakes that have been made in the past or the damage that has been suffered. We can only apologise for what we got wrong, and I repeat that apology, and do our utmost to ensure that it doesn't happen again. I hope that our closing submissions have gone some way to demonstrating our continuing determination in that regard. And can I make these two very short observations in conclusion? The first concerns the inquiry team, including but by no means limited to your legal team. So you will know better than anyone that the last few phases of this inquiry have been run to a demanding timetable, which has led to everyone concerned working under considerable pressure. Notwithstanding those pressures, UKGI has been treated throughout this investigation with the highest standards of professionalism and courtesy by the entire inquiry team, and we would wish to record our thanks and appreciation for that. And finally, UKGI would wish to conclude these closing submissions by addressing the postmasters and their families whose lives have been irreparably damaged by the tragic and unjustifiable events with which this inquiry is concerned. UKGI has paid close attention to the evidence given to this inquiry from the outset, including the human impact hearings and focus groups. Representatives from UKGI, including our Chief Executive, General Counsel, members of our board, have spent many days in this room listening to evidence, much of which must have been incredibly difficult for postmasters and their families to hear. The dignity and resilience that they have shown during the inquiry, as indeed with the fight for justice which preceded it, and which still continues, has been remarkable, and all of those involved in this inquiry, both within and on behalf of UKGI, would wish to pay tribute to them. So thank you very much.
Thank you, Mr. Shelburne. Well, I think we are on schedule, and we will resume again at 9:30 tomorrow morning. Yes, Mr. Beard?
That's correct, sir. Thank you very much.
All right. See you all in the morning.